Yeah. Mhm. Without the consent for the court to issue a protection order, I don't think the alleged victim could be pleased with the actual issuance of any sort of punishment for perpetrating a crime. Yeah. As in, she didn't want it, right? But you decided to do it, Brent. Now, the construction law does not work any injury. The nice part about domestic violence laws is they don't work any injury. If you give me notice and opportunity to be heard and you give me a fair hearing, I will not be injured by the court issuing any court order because the court order is issued according to the requirements of the law. Now, this construction of law does not work any injury. When you decide to issue court orders without the consent of the petitioner, yes, it does work injury because the petitioner would have to know that she was not victimized by myself as the named respondent because I wasn't in Brennan Church and I wasn't in Swim. Now, when you take the construction of the law and decide to injure, yes, it's beyond punitive damages. It actually goes beyond tort damages, as difficult as it is to believe that. See, when the laws of construction so that are constructed so that it does not work any injury, neither the petitioner nor the respondent, nor the minors named, yes. And then in the event of violating a court order, the victim, and the defendant, right, do not have any injury worked against them. But when you decide to use 1077s, you work an injury, yes, that the law did not construct. Yeah. Now there's a lawsuit in there if you can see it. Oh, it's Latin, constructio legis in factum injuriam. Now, the law never permits anything contrary to truth. Yeah, I thought this was a really good one because every law of the United States would never permit anything that is not truthful. Yes. This idea that you as a court commissioner have the jurisdiction to issue a court order without the consent, acknowledgement, or the receipt of the order to the petitioner, that is contrary to truth. The petitioner would have to want the protections for you to be able to issue it. The minors named, yes, contrary to truth. I was never a credible threat and I never committed domestic violence or oh, child abuse. Now, the truth that you believed was that the petitioner said that she experienced domestic violence and child abuse. Right. But she didn't. Now, the law never permits anything contrary to truth. You cannot say that I was in Brennan, Washington when I was in Port Angeles, Washington. You cannot say that I contacted people at the employment of my wife when I never emailed them. You cannot say what is contrary to truth because the law never permits anything contrary to truth. Now, the only thing obstructing me from having you put in prison, and I would say public defender and prosecuting attorneys, yes, is your refusal to enforce the truth. Ooch. Sheriff. Okay. Now, contrarius ad mentem partitium verbis notetum intelligentus. A contract should be understood according to the intention of the parties expressed in words. These contracts, known as court orders, yes, they should be understood according to the intention of the parties. What was the intention of the petitioner not signing it? She didn't want the protections, right? She did not think that I should not have the availability of communicating with my sons, yes, and speaking to her. If she had wanted me to not be able to do that, she would have signed the contract. Okay. Now, uh, a contract with the state of Washington should be understood according to the intention of the parties. There's two parties named in this, and then there's the parties known as the minors, right? And then there are the parties known as the commissioner, the ex officio superior court clerk, and the county court clerk. Yes, there's actually 5 minors, the petitioner, the respondent, the ex officio Superior Court clerk, the court commissioner, and then the Clallam County clerk. Yes, there are definitely more than 2 parties in this contract. Yes. Now, it should be understood and according to the intention of the parties. What was the intention of the court commissioner, Brent Baisden, in issuing a protection order and a weapon order to surrender weapons? Yes. Was it his intention to obstruct my right to custody of my sons? Yes. You issued it for 10 years. Now, what was the intention of using a forgery? You were going to issue it without the actual consent of the ex officio Superior Court clerk. Right. What was the intention? Now, according to the intention of the parties expressed in words, you wouldn't think of the signature of myself as being a word, but it is. Actually, Paul Chad Budnick's 3 words. Let's look at it. Okay. This whole idea presents a serious and imminent threat to public health or safety or the health or safety of any individual. Yeah. By possessing a firearm or other dangerous weapon. Yeah. Now, you didn't mark any of the boxes there. Good for you. But you would say that they are not applicable to the actual contract because there is no actual slash in there. So you slash this one, protected person. All right. Slash this one, petition for any order for protection. You slash this one, surrender is mandatory because, I did not have actual notice and opportunity to be heard. You would say that this contract only has enforceable what you yourself have marked. Yes. You put a little check mark right there. Yeah. This is page 2-3. You put a little slash right there. Yes. But the problem is these contracts that have all these other words that you don't think are actually pertinent to what the court does. Every word on every court contract has meaning whether or not they apply to the parties named. Let's say I found out there was the fraud of the forgery of the ex officio Superior Court clerk. And as much as you say I can't do this, I think I can. This, on page 3 of 3, Christy Miller, was signed under arrest that somebody said that I had, yes, actual weapons. But this and this are not the same. No. Now let's look at it again. This and this are not the same. Right there and right there. Now, let's say you use a forgery, right, to issue a court order, and every word of the contract is a liability. Oh, the contract should be understood according to the intention of the parties expressed in the words, and as soon as you have one untruthful statement, one misrepresentation, yes, one fraudulent statement, as soon as you as the court use a forgery, you are personally liable for every word. Now I'm suing you. I'm suing you because of the lawsuits that I've already described in detail where you did mark the actual forms. Now I'm suing you for the use of fraud and forgery for all the parts of the form right now. And it's a big fucking lawsuit. Okay? A contract should be understood according to the intentions of the fraudulent parties known as the court commissioner, the ex officio Superior Court clerk, yes, the non-existent petitioner right now, expressed in the words that were not enforceable but were on the contract. You're sued.